Thank you very much, Senator Fraser-Binns. Apologies for absence. I know that Senator Morris is on way. I want to welcome you to this meeting. We have some minutes for two meetings held, one on the 2nd of February 2024, and we have another review document that has been circulated to look at. I want to use the time allotted to us today really for us to try and just determine a way forward so that we can complete this process hopefully in the first half of this year. So what I'm going to do is to go through the minutes for the meeting of the 2nd of February, and I'm going to ask members to, in case I forget, what we are going to do, you don't have to wait for notification from the Secretary as to the meeting of the committee. Once the Senate is sitting, you can be assured that we are going to meet here, because we need to just get through this process as quickly as possible. Yes, standard agreement. Minutes of the meeting of the Senate Standing Orders Committee held on Friday, February the 2nd, 2022. First page indicates the members who were present. Absent were Senators Scott Motley, Fraser-Binns, and Bram. All other persons present were recorded. Page 2 deals with essentially section Standing Order 61 and consequential amendments to bills, and there was some extensive discussion with Senator Morris making a contribution, as did Senator Gale. So any amendments there? On page 2, it is noted at the top of the page that the committee agreed to revisit this at a future time, and that is 61, Standing Order 61. So we are going to have to really set a day aside when we can look at the matters that we have put for revisiting. And we looked at 62. The committee did not propose any change to that order. Likewise, 63 and 64. Now, 65, it seems, from the minutes, had created some discussion. So I'll put page 3, or identify page 3 to you, and page 4. So can I get a motion in relation to the minutes? Senator Gale, seconded? Seconded? Were you here, Senator Sinclair? In any event, you were in fact here. So the minutes are agreed. Now, if you look at the last page of the minutes, and I refer the committee to section 65. Morning, Senator Morris. If you look at the last page of the minutes, page 3 of the minutes, it says, the chairman noted that the previous Standing Orders Committee had commented on the reference to order of council was incorrect, and therefore recommended that the words Jamaica Constitution, order in council should be replaced with the Constitution of Jamaica, and the words that order in council should be replaced with the Constitution. So this is 65, right? The chairman asked the Legislative Council, I think it was Yes, the chairman asked the Legislative Council to present to the committee a note as to what was contained in 56 and 58 of the Constitution, which was mentioned in Standing Order 65. He also requested that she review the recommendation made by the previous committee to determine the proper way to refer to the Constitution. Mrs. Wilson agreed to do so. Senator Morris said, and I quote, "Order in council was a pre-independence reference, whereas the Jamaican Constitution came after the country gained independence." Mrs. Wilson said that she had a hard copy of the Constitution and confirmed that the reference made to the title Jamaica Constitution, Order in Council 62. She stated, however, that she would further research the matter. And Ms. Wilson, we have in fact a memorandum from Ms. Wilson, Legislative Council, and I'm going to ask her if she could present in relation to this matter. Now, could I just ask the membership if you want just a few minutes to just review where we are at? Are you good? You want to look back at 65? Eh? Read it for us, Senator Sinclair.
65, that is dealing with the financial procedure.
Yes.
Which reads as follows. A bill brought from the House of Representatives endorsed with a certificate of the Speaker that it is a money bill shall be subject to sections 56 and 58 of the Jamaica Constitution, Order in Council 1962, and any other bills shall be subject to sections 55, 57, and 58 of that Order in Council.
Okay, so the decision or the issue revolves around the use of that particular phrase. And we had asked Ms. Wilson for a paper on it, a note on it, which she has presented. I don't know if everybody has a copy of the note. Yes, okay. So Ms. Wilson, over to you.
Good morning, members. I believe the concern was as it relates to the citation used to refer to the Jamaican Constitution in Standing Order 65. I consulted the Constitution itself, and Section 1.1 of the Constitution reads that this order may be cited as the Jamaica Constitution Order in Council 1962. So based on that, I believe that the official citation when referring to the Constitution should be the Jamaica Constitution Order in Council 1962, as is stated in Standing Order 65.
Okay, any questions? So what you are saying is that 65 is correct in its designation?
That is so.
Okay, any other comment? So, Madam Secretary, we go to 66? Was it done? Okay. Okay, 1 minute. Madam Clerk, talk now.
There was an outstanding matter on Section 60, where Standing Order 60, where Senator Scott Motley had asked about how it was used, and the clerk had been asked to do some research on it. The research was ready at the last meeting, but Senator Scott Motley was not, so you had deferred it until she was present.
So, the clerk to our committee had indicated that there was an issue with Standing Order 60, and the request was made for research with the aim to determine how Section 60 of the Senate Standing Orders was utilized in past deliberations of both houses. Now, let me just try and pick up. Senator Mott, you can pick up where your concern was?
Chair, I'm just looking at the research paper. Was that research paper deliberated on at all? Because perhaps...
No, we were waiting for you, you know.
So perhaps what you could do is go through it, Chair, so that all of us...
But what I wanted you to do is just give us a background again as to what the concerns were. And then I'll ask the...
You put me in a very embarrassing position.
No, it's not meant to. I'm trying to understand. It's okay, no problem.
I would like to look at the... In the heat of that debate,
okay,
I had expressed some reservations.
Okay.
So which I think would be captured by the research paper.
Let us go through the research paper then. Madam?
No, I think the issue, Senator Scott Motley had not highlighted her specific concerns in the meeting, but she had been asked by the chairman to speak directly with the clerk about it after the meeting. So it would have been a discussion between both of them.
Okay, I understand. Madam, Ms. Lowe?
Hi, good morning, everyone. This research was done by our internal researchers, so Ms. Patterson will just
Ms.
walk.
Patterson, okay.
Will help us.
Ms. Patterson?
Good morning, everyone. All right, there was a research done on section 60. In regards to the ROPA hack. All right, so there was, in 1989, this was when the ROPA Act was first presented. It was...
Okay, so on the record of the meeting on January 26th, when the issue arose, Senator Scott Motley went into her memory to see how these standing orders had been used in the past. And she mentioned the two examples, and then she requested that some research be done as to whether it has happened in recent times, where bills were rejected by the Senate and yes.
Sorry, go ahead, Senator.
Don't want to stay on the green. So we had actually been discussing as to whether there were examples of where the Senate had disagreed with the bill which was presented by the House and had expressed a disagreement and sent it back.
Okay, so what we were looking at specifically, would have been 64C and 5.
Yes.
If such an amendment have been disagreed to, shall be sent. If such amendments have been disagreed to, a message shall be sent informing the House of Representatives that the Senate has disagreed with the House of Representatives amendment to the bill. And 5, where the Senate has disagreed to the House of Representatives amendment, if the House returns the bill with a message that it insists on the amendment, the Senate may agree to the said amendment, to which case the provision of paragraph 4A shall apply, amend such amendments, in which case the provision 4B shall apply, postpone consideration of the House of Representatives amendment to 6 months. Order the withdrawal of the bill.
Right, and I
So
thought,
what's it- yes.
I thought it was significant that the Senate could order the withdrawal of the bill and do all, had the power and the authority, and wanted to know if there was a time, if we could do some research to see how it had been done in the past.
And thank you very much. So we are back in context. Ready for you now, madam. Yes, Senator.
I just want to reiterate the significance of that particular standing order to show that the Senate is not to be a rubber stamping institution, because the Senate can reject bills that come from the House of Representatives. And that is why the Senate is the review chamber. And whilst both houses have the responsibility and duty to review bills within the context of the Constitution, there's a greater premium that is, greater burden that is placed on the Senate where this is concerned. So we have a major responsibility in the Senate.
Thank you very much. And indeed, it certainly raises the issue when I've heard my colleagues say, well, it's just the Senate and we review, but that's the extent of our authority. It's not really so. So I'm going to ask that we listen to the result of the query from Senator Scott Motley.
Okay. All right, so the aim of the research was to find out how Section 60 of the Senate Standing Orders was utilized in the past for deliberation in both houses. All right, in 1989, an act to amend the Representation of the People's Act ROPA was first presented. On December 16, 1988, it was tabled in the Honorable Senate, and then which was brought from the House of Representatives prior. However, one member of the Senate was not in agreement with Clause 7B of the Act and wanted to amend, and I quote, "the public at the same time." The following, I'll give an example. The following is a synopsis of the conversation had. Read Senator Miller, who brought up this issue with the wording of Clause 7. It stated, "It is the administration that is making the change. It doesn't say, it says the candidate must be informed in writing. It doesn't say how the electors are to be informed, but whatever means they are going to use, that the information go at the same time, which means that the process can begin." Based on this proposed amendment, this point was also raised by Senator Arden, and I quote, "I don't know if the drafting would be correct, but assuming that that is correct, it means amending the bill, which means in turn would go back to the other house, but not just that, it has to go back to the two political parties to get them to agree with what the proposals are." Another senator, Senator Worrell, was also concerned if this amendment would create further problems if the elections would be affected. This one? Hello? Senator Worrell was concerned if this amendment would create further problems with the upcoming elections. His comments are as follows. I would like to say that the integrity of the political process has to be safeguarded and protected, and I mean the political parties, but we cannot in doing that ignore the integrity of this parliament and this chamber of this parliament. But I do take the leader's point that if it would not be generous to the people who have worked so hard on this change at the bill in a way that forced the delay in any significant. I should have thought that we could all do these things that are necessary, get the bill out the way quickly, but still find an amendment that reduce extremity of this cause. The highlight of his comment was, I believe that if we thought hard about it and probably communicate with the leaders of the political party, our intention, we might be able to at least, by the next sitting of this parliament, probably today, sort this thing out. And I end that quote. All right, so at the end of to the latter of the meeting, a proposal was made by Senator Arden. He stated that it would simply defer the debate of the particular points as he wanted to get tacky either for, as he didn't want it to get tacky for the next sitting, and he asked for the meeting to be deferred so that they can have a consultation. And the insert was made which showed the particulars of the interaction between the President and Mr. Arden. All right, so after the consultation, the private consultation that is, the President of the Senate then plays Clause 7 as amended, given that the Senate had agreed to it. On January 4th, 1989, an act to amend the ROPA Act was brought forward again from the House of Representatives. That this is after they had... Yes, so after they had come to an agreement, it was then brought again to the House on January 4th, 1989. Yes. All right, and I had inserted the following recommendation, which was brought forward from the Honorable O.B. Golden.
Let me just thank. I don't mean to interrupt you, but let me just point out to you so you can go ahead. You would recognize that when a bill comes to the House, we as members of the Senate are authorized, in fact, actually expected to make amendments to it and return it. And this is the process that's going on here. But the issue here is that it's because it's a representation of the People's Act, where a decision had been made that once amendment comes to the ROPA from the Electoral Commission, then it is agreed in the Parliament and the Senate. And that is what I think is causing the problem here, because it passed the lower house. So this is not really an example. It passed the lower house with agreement coming from the Electoral Commission or the Electoral Advisory Committee at the time, after consultation. And that is why there is reference to leaders of the both houses, because there is a reluctance. There was a reluctance in the Senate to amend it when it was not amended in the lower house. So that is what I think is causing the issue here, because it's ROPA.
But, and I think there is somebody in this room who ought to have been part of those deliberations. But what I find, and I think it's very important for us to focus on, is that the Senate at the time, both government and opposition, were bold enough to, in spite of that agreement, look at what was before them and find fault with it, so that it had to be deferred and sent back for comment. And I think the comment which was made in the House by Honorable Bruce Golding also reflects how it is that the kind of approach which was being taken then to matters such as this. Because even though he accepted it, he was still concerned about it.
The officer to just complete, because I interrupted her. You can complete and then we'll have a discussion on it. Your mic is on? Okay, go ahead. I wasn't in the Senate, by the way. Go ahead.
Okay. All right. As mentioned, the ROPA Act was brought forward, was presented again on January 4th, 1989 from the Senate. I can read the recommendation brought forward by the Senator. Go ahead and read it. Okay. The Senate, in its wisdom, was of the view that the public should not be treated with any less urgency than the candidates, and felt that if candidates had to be notified within 24 hours in the case of changes in polling stations' locations and within 5 days or at least 5 days before election day in relation to division of the list, then the public should also be notified within that time. It had occurred to us originally, but there was always a problem in terms of defining how do you notify the public and how can you ensure that the public is notified within 24 hours. Do you put an announcement out on the radio? Do you put an ad in the paper? And suppose the radio stations are not able to accept any advertisement, and suppose the newspapers are on strike, what do you do? But I gather from the legal draftsman that notification to the public, that requirement can be satisfied without concerning ourselves with these practicalities of inconvenience. So that I, as the minister responsible, Mr. Speaker, offer no objection to the amendment, and I, in fact, urge the House to consider them favorable. Further conversations were held, and the result is highlighted below. So I am glad the member had raised it. It's a matter that I think we need to have some discussions on. It's a matter, quite frankly, that we would love to have public comment on, and to hear what the public's view are. And we are speaking for the government and the speaker for the party that I represent. We would certainly be prepared and willing to join that discussion and to make our own contributions to that debate. But because we believe that it is an issue that has to be addressed. Subject to these comments, Mr. Speaker, I invite the House to accept and approve the amendments to the bill entitled An Act to Amend the Representation of the People's Act, as has been referred by the Senate. The Speaker commented, the question is on the Senate amendment to the bill entitled An Act to Amend the Representation of the People Act be now considered and agreed to, put to the House and agreed to. So on January 4, 1989, this was the last time the bill was presented, and there was no further indication where this act was brought up again. Thank you.
Thank you very much for that bit of research, and we appreciate the time that you spent on it, and it has been very useful to us. So we thank you very much, and record your thanks, or the thanks of the committee in our meeting. So what we really have here is a situation where it wasn't really just an amendment to a ordinary bit of legislation, but I think that the issues of the Senate not agreeing or agreeing to it, or although I'm not seeing it specifically noted, but I suspect that it is because it was ROPA why the matter gained this level of attention. Because as you know, in normal course of things, we would make amendments to legislation and send them down. So I thank you again, and I thank Senator Scott Motley for raising it. Senator Scott Motley.
What is clear, though, Chair, is that it would be highly unusual for the Senate to order the withdrawal of the bill. But it is good that the Senate, by going through this standing orders, is made aware of the power that it has. Now, interestingly, if we had a situation where whoever appoints the Senate has a right to remove the senator, then that would add even a more interesting dimension. Because if the Senate were bold enough to say, no, this bill has to be withdrawn to the House, it might have some very serious consequences for the Senate. But I return to my point, which is that the Senate has considerable powers as a review chamber, which it might choose not to exercise. But it's good that it's aware that it has the option.
Thank you, Senator Scott Motley. And thank Senator Scott Motley, thanks for really bringing this to our attention. Senator Fraser-Binns.
Thank you, Chairman, and let me also thank the researcher for her work. The agreement when it comes on to recommendations from the ECJ, but I wasn't aware of this particular instance. I'm very, very happy that you brought it to our attention. Chairman, not to delay the deliberation on this section, but perhaps more for academic discourse, I wondered whether through you we could do some further research, Madam Clark and your team, as to whether in independent Jamaica there has been any instance where 60 subsection 5 has been evoked. I'm particularly piqued with the powers here, and as I said, not to delay the deliberations, but more for academic discourse. Thank you, Chairman.
I think that if you could, because as I was saying to you, I think that ROPA is different, and that is what was causing or why some attention was brought to it. But I don't think that she's going to find an event where the Senate actually said no, because in normal circumstances, you end up dividing on party lines, for better or for worse. Senator Gill, and then Senator Sinclair.
Chairman, let me thank Senator Scott Motley for going into her memory. And thank Ms. Patterson for jogging our understanding in relation to this. One of the things it points out to us also, because clearly there was a clear understanding that something would have gone wrong with this particular bill. And it showed a level of collaboration between both houses of parliament in coming to an agreement. And this is where you leave party lines at the door and coming to the chambers and have some sort of a consensus towards agreeing on what could have been a challenge. But like Senator Fraser-Binns in seeking around 65, I'm asking particularly some clarification on 65C, where it says postpone the consideration of the House of Representatives amendment for 6 months. That creates an expectation, and I'd want to know at some point in time what is expected there after the 6 months.
Well, I think that this is, I don't want to use the word peak,
Yes.
But this is where the Senate would say, look here, we're not going to consider this again for 6 months. Rather than sending it back, you simply say, all right, you're going to adjourn this for 6 months. Good luck to you.
And so that happens, really.
Chair, I think...
You can't be left like that, President, Chairman.
Given my very, very young age, I can't... I won't even think that I can, consider what the framers brought to their mind. But just in terms of our profession now, in mediation, there's a thing we call a cooling off period. Say when you're in mediation and things getting a little hot, we kind of say, let's go to the balcony, where we allow the minds to be cooled and reason can prevail when we reconvene. And I'm just wondering if perhaps the thinking of the drafters at that time was to give a cooling off period where persons were able to think through rationally and then come back to the table. I'm just wondering.
Senator Scott Martin, you wanted to say something?
I was in fact thinking that it would be a period during which consultation and deliberation could take place so that both sides could ventilate their thoughts and arrive at some kind of understanding during the 6 months.
Senator Sinclair?
In relation to the comment on 65C, 65C, when you look at what 65 is about, because it speaks to a situation where it would have come to the Senate, gone back to the lower house, and then we are disagreeing with their situation. So obviously the two chambers are at loggerheads, if I could use that. So I think the 6 months obviously is one, as Senator Scott Martin has indicated, which allows for further deliberation and probably even wider consultation between the members of the House. The executive can relook and to see whether they can make amendments that can bring all parties onto the same page. But what is the significance of Order 60 and particularly 5? It does show that the Senate is not just a rubber stamp, as Senator Morris has said. And, sometimes persons on the outside will look on the Senate as being a place that, well, whatever comes from the lower house, from the government, is something that is acceded to. I don't want persons to believe that it will necessarily happen, may not necessarily happen, and I don't think we can find an actual point.
It's an opportunity.
Yes, in spite of the research, that you may find that D is used, or even C, for that matter of fact, is used, but it does indicate that we have great responsibility in the consideration of what comes before us. And I suppose you'll find it arising in situations, especially where constitutional matters are at stake, that you would find a situation that the Senate that is doing a review, who are made up of persons, are expected to be made up of persons who would have high regard for the Constitution, and not just as to other things that persons who are elected could feel in relation to particular aspects of bills, that you can find these situations arise in C&D. The independence is reflected in C&D.
Yeah, well, I don't think it's something, I think that Senator Safari Longmore wanted to just say something briefly, and then we can move on to something else.
Thank you, Chair. I for one, apologies for being late. It was unavoidable. What for me is enlightening is the provision, is the 6-month provision that I was unaware of, and I mean it serves to the Standing Orders Committee for us to recognize and propagate this awareness. But I think that, I don't see any need for any changes at this time. I think it's just appreciating what is there. Thank you.
Good. As I said, thank you, Scott Motley, and thank you for the officer that did the research for us. I'm going to, just before I close off, it's 2 minutes past 10, just before I close off, I'm going to bring to your attention the document and thank our secretary. There's a document here that says Standing Order Committee of the Senate, decision taken in respect of the standing orders. Update to July 3, 2024. So if Scott Motley and Longmore would stop talking there and paying attention, I'm losing control over this committee. If you look at this document, then what I'm going to suggest to you that we actually spend the next meeting, Senator Sinclair, because I mightn't be here, just spend the next meeting going through this, and there are a number of areas in here that you would find that we had made an issue of in terms of going back to recommend it. So what I would like you to do next week is just to formalize this, and then we make a decision. Hear the decision that we have to make. Yes, no, hear me. Hear the decision that we have to make. Do we stop and prepare this, or do we make a decision to go hell for leather, as they say, to finish?
Chairman, I'm giving a third option of doing both.
Okay.
Meaning that we can continue our Friday deliberations, and perhaps with the members' agreement, can have a special day where we sit down and look and review what we've done today.
Okay, so I'll make that, Senator Sinclair and you all make that decision if I'm not here on Friday. Okay? But I don't know, I don't want to, let me tell you something. There is something. Off the record, there is something downstairs that when he sees it, he might determine that he's going to be more forceful as a potential president. But I'm not telling you what it is. So this meeting is adjourned for a date to be fixed. Thank you very much for the members of the parliamentary staff. Thank you, Madam Secretary. This meeting now stands adjourned. That is not for the record.